I'll go to Senior Advocate Amit Desai. Now, I'll tell you a dilemma which happens. Any big business has got multiple arbitrations of high value running. Generally happens when they do business with the government or otherwise. And many times they will come up with thing that if I am inside, who's going to take care of all these arbitrations? I may end up losing a lot of business. And they want somebody to track because you have to strategize, you have to make people appear. And these days arbitrations are a part of our business. So do you think that as a whole, we have to relook at this whole process of bail where businessmen are involved, where economic value creation is involved, where money receivable and money going in and out of the government is involved, where contracts are being executed? I mean, is there no other solution than just picking up that man and throwing him in jail when there is so much going on? And also the message which goes out of India, if this happens here, promoters tend to get scared. Some people may get scared to invest in India. How would you look at this thing?
So, Tarun, let me tell you, the first thing is what the law of the subject is. And this, again, it's law which is settled many, many, many decades ago. One of the principles for consideration of bail is that if he is on bail, he is in a better position to attend to his defense in the case.
Yes.
This is an established principle. In fact, it is one of the observations that was made as far back by Justice Tishnayar while considering various principles for grant of bail.
Yes.
Now, we extend that same principle that in today's complex business environment in which we live, it is not just about the defense of that one particular case. It is about so many other aspects of the running of the business, so many other litigations, so many other arbitrations, where if he is a free man, he has the ability to handle all those litigations. There is no doubt and there's no difficulty about the grant of bail. The question is, how do you implement it and apply it? Now, that is where one approach could be, and I mean, it's not very easy, is that one of the suggestions was the Bail Act, which was thrown out for discussion. I must tell you that this concept of the Bail Act is something which has been discussed about for years. Many earlier judgments also talked about a Bail Act. And I must tell you that in 2015, the law minister actually made a recommendation to the Law Commission to say we should consider bringing in a Bail Act. And then it was decided that maybe we should consider amending the CRPC and bringing about some changes in the CRPC. And the underlying principle, if you look at some of the conclusions of the Law Commission, and interestingly, the Law Commission, after detailed analysis, the three conclusions that they came about with after analyzing everything, I'll just read three of them. The practice must be fair. This is about grant of bail. Must be fair and evidence-based. Decisions about custody or release should not be influenced to the detriment of the person accused of an offense by factors such as gender, race, ethnicity, financial conditions, or social status. The practices should address two key goals: protecting against the risk that the accused fails to appear and protecting against the risk to the safety of the person or the community. And last, unnecessary pre-trial confinement should be minimized. Confinement is detrimental to the person accused of an offense who is kept in custody, imposes unproductive burden on the state, and can have an adverse impact on future behavior and reform. Now, these are the three conclusions even of the Law Commission, which is of 2016. Now, the question really for us to think about is, you're right, that there is a need to, because these are all established principles. The government also thought that there's a need for a bail act. And the reason for a bail act is because under different legislation, there are different bail provisions. Probably it is best to have bail considered in one statute rather than have one provision for the NDPS, one provision for POTA, one for the SFIO, one for the PMLA, one for the normal law. Put it in one code, have the principles set out there, settle the criteria, make it rule-based, and leave it then to it. That's probably one approach. And in fact, that's where in this judgment of Justice Kaul and Justice Sudresh, one of the suggestions was, let's consider a bail act and let's try and bring about, because you're absolutely right. This is something which will actually help the economic environment, as Justice Sikri has just pointed out. And this is something that we have struggled with, is how do you bring on the balance between the economic needs of a business, the economic needs of a business which contributes to the community, to the taxation, to the welfare of the people who are the stakeholders in that company, versus keeping the man who is actually the person who is able to run the business in custody. This happens in a lot of what are known as these depositor cases. MPID and many states have these cases relating to protection of depositors. In many of those cases, the promoters are taken into custody. Now, the object of the legislation is actually to get the money back for the depositors. By keeping the promoter in jail, the depositor is not going to get his money back. And many, many years ago, there was one learned judge of the Bombay High Court sitting in a vacation actually has rendered a judgment saying, by keeping this man in custody, he is not going to get the depositors their money back. It is better that he comes out, runs his business, earns the money, and pays the depositors back. Now, this principle, which is so crucial, must get now codified, if I may say so. But before it gets codified, because codification in this country is going to take a long time, I think that it is necessary for some very prescriptive guidelines from the courts to say that if these are the factors, we should consider granting.
So Senior Advocate Amit Desai says before the codification, a prescriptive guideline the courts could themselves issue, and that would be the starting point to go for. I'll go to Senior Advocate Saurabh Kirpal for his intervention.
The biggest problem we have, and that is the root cause of this discussion also, is that the belief that somehow economic offenses are much worse than any other offense. And you need to keep a person in jail because they've committed some economic offense. Now I ask myself, are you honestly saying that a person who has not paid customs duty is more of a criminal, hardened criminal, than a rapist or a murderer or a robber? This flies contrary to all logic. Now, there was probably some stray line that came in a judgment 20, 30 years ago that these are economic offenses and they are also of serious nature. The idea was that just because they're economic offenses does not mean you start treating them as mere technical or regulatory offenses. They're also crimes. From that perspective, which was to make the judiciary aware that economic offenses are not meaningless, we have now gone to the other extreme, that somehow economic offenses are the most heinous offenses that could possibly be committed. Now, I fail to understand that if we live in a society where someone doesn't pay tax, but on the other hand, they have hundreds of people who are committing all kinds of offenses under the IPC, and they taken less lightly. In the criminal act, under the IPC, you don't have these stringent conditions for bail for robbery and murder. You don't have the twin conditions. You have that in PMLA. Now you have that in so many other regulatory offenses. That bail is very, very difficult in economic offenses. Now, what is special about economic offenses that you're not letting out these people, that you're putting them in prison earlier? And the answer is very simple. And that is where I think the problem lies, is because as a country, we are unable to convict after evidence. So very often the belief is there in the subordinate judiciary and indeed even the higher judiciary, and Justice Sikri can clarify this, is that process is the punishment. You know that the person is going to be ultimately acquitted because virtually nothing results in conviction in our country. Conviction rates are abysmally low. So you want to give a dose to someone saying, oh, you've done something wrong. I know you won't go to jail finally after conviction, which will take in any case 20 years. So this is the time when you will get punished. So bail, rather than serving a purpose of actually assisting investigation, becomes a form of punishment. But the problem is, while punishing the individual, you end up punishing the company more. And you end up punishing the economy of the country a lot more. So while saying on the one hand that economic offenses are serious, the net result, and that's the judgment of Justice Sikri Sugar Mills. So what is the effect of your keeping someone in custody for such a long time is to make a detrimental impact on the very thing that you say is bad, which is the economic effect it has on the country. So this is, I think, something...
while accepting what Saurabh has said, we'll add a caveat so that our message is not misunderstood. We are talking about bail to persons who are under trial and they are facing the accusation which has not been proved. Yes, economic offenses, if you see from economic point of view, if these offenses are committed, they also have adverse effect on economy.
Yes.
So they should be sternly dealt with, but only after conviction.
Yes.
After conviction, punishment can be severe. But then you cannot give that treatment, as Saurabh has rightly said, treating them as a convicted person even at this stage.
Sir, I want to ask you one thing, because you said this. You told me, shared with the viewers on one of the much earlier shows, I think 4.5, 5 years ago, that is the duty of a judge to nudge the executive and come back. Do you think that Justice Kaul and Justice Namara and now Ramana are now nudging the executive that make this new bill law. But can this law be made without the help of retired Supreme Court judges advising on it and taking inputs from eminent senior advocates? Can this be formulated without their input? The executive per se is not able to do it.
No, you are right. Executive per se may not be, but good thing is Justice Kaul and Justice Sundesh, they are seized of the matter. This is pending as well as I told you earlier also. Justice Ramanna has made a statement in one of his lectures. But insofar as Justice Kaul and Sundesh are concerned, they have penned down these thoughts in a judicial order. And not only that, as Mr. Amit Desai also pointed out, that they are monitoring this matter. So therefore, they can always nudge the executive. They will, and as I know this bench and their capabilities, I'm very sure that this bench is not going to leave at that. They will try to at least, even if ultimately, I don't know, tomorrow the executive or government may come out with this, that no, law is not necessary. But in spite of that, I think in some form or the other, they may, express their thoughts in the form of an order, which is a judicial order, and such an order coming from the Supreme Court will have the effect of law. That is, any judicial order passed by the Supreme Court is the law of the land. So some way, and of course, it is always open to a committee can also be formed for this purpose. That the suggestion may come from the bench that, look, you may take the help of these senior advocates who are experts in criminal law, or those draftsmen who are very good draftsmen in law, etc. All these persons can join together. Ultimately, it would be up to the executive. But then these kinds of suggestions can be given. And if the executive is receptive to this idea and thinks that, yes, what is suggested in this judicial order, it commends further action, then probably, better things may come out.
I want to ask you one follow-up question before I go ahead. See, in this country, we have seen that for an offense, which is a minor offense committed by some officer in the company, promoters are summoned. They end up skipping the appearance, and then warrants are issued. Many times promoters don't even live in this country, but they have a warrant against their name. And that's why this issue is serious. Do you think the judiciary and the executive will be on same page on this one? Because executive is also talking in the same language that India needs investments, we need money to come in, and pendency is too much, so resolve pendency. So they are worried that if there is a perception that people can be thrown inside jail for any small thing, then investments may not come in the way that they should come into this country. So do you think the executive and the judiciary will now, at least on this, be on the same page?
The possibility is there. If I may say so, if you remember, in recent past, there are amendments made in certain laws.
Yes.
Those which were earlier treated as criminal acts, they are decriminalized.
Yes.
And they are only, now fastened with such kind of, I would say, irregularities or commission of such kind of acts are treated as civil offenses. There may be penalties, but then they should not be treated under the Companies Act also. Many such amendments are made. So therefore, I think the government or the executive is conscious of this fact when we talk of having FDI and ease of doing business and sending such kind of message. Then we want to have 5 trillion economy in a couple of years from this. So if we look into all these aspects, then the executive is bound to and is supposed to keep in mind these factors as well. So if the executive goes honestly on these, as far as these issues are concerned, judiciary in any case, as this bench has expressed, wants these things to happen. Possibility cannot be ruled out that they are on the same page, but good intentions are needed for this.
So now we are almost out of time, so we will take final one minute comments from each panelist. I'll ask Senior Advocate Amit Desai, you hopeful that things will change for the better, in the hope that we saw our Prime Minister is also going out and actively canvassing for investments to come into India. You understand the world of business better than most of us. Do you think psychologically, when somebody puts in money, he looks at the legal ecosystem in this country? Any investor would do. One small comment from you at the end of the show.
So I'll tell you, I think this particular judgment of Justice Kaul and Justice Sundresh is a significant step in the right direction. I think it's a very strong message which has come from the Supreme Court, which should also give some kind of comfort to the business community that every time there's a case against them, they don't have to go to jail. There is one other interesting development which is also happening. Because just as Saurabh rightly brought out the aspect of arrest, there's one other aspect which has affected the business community in the context of these, and that's called the lookout notice. So every time there was a default, the lookout notice and it restrained their ability to travel, which had serious implications, very similar to the implications of an arrest. The Nagpur bench has recently struck down the power of the DRT to detain the passports and issue lookout notices. The Bombay High Court is currently reserved judgment on the power of the public sector banks, whether they can issue lookout notices. Step by step, if we have these decisions and they move in the right direction, then the last impact is in relation to criminal investigations, where lookout notices are issued not only to suspects, but also for witnesses. That's the other step which needs to be pulled back, because the principle in relation to right to travel, which is so essential for a businessman, who even if he's facing an inquiry or investigation, is that there was a Satwan Singh judgment in the Supreme Court in 1970, where even during an investigation, people are allowed to travel. This is a fundamental right. So if we are able to move in that direction again, then the three stages, one is the lookout notice, the arrest, and the bail. If all these three are moving in the right direction, I think that there is a lot of hope for the business community to sort of look back at India and make their investments.
Thank you for that comment. I'll go to Senior Advocate Saurabh Kirpal for his closing comment.
I'm probably a little less sanguine and hopeful about the impact of this judgment. This judgment is not laying down new jurisprudence. It simply has reiterated that what Justice Krishna Iyer said, or in fact has been our jurisprudence for the last 70 years. If in the face of that jurisprudence, every day we still attend court and find that the subordinate judiciary is not granting bail orders, I don't think another one judgment is going to do very much to change it. Very often we think, let's take the easy way out. One judgment will come and a magic wand, everything will change. That is not how subordinate judiciary will change. We need to have active training sessions or some judicial academies where it is impressed upon the subordinate judiciary that you must grant bail. And let me tell you, the fault does not lie just with the subordinate judiciary. Very often the subordinate judiciary is worried about passing an order of bail because immediately the government will file an appeal or seek cancellation of bail, and the high courts will entertain that, sometimes pass strictures against the person who's granted the bail, or will make some kind of adverse comment and proceed to cancel the bail. So even the subordinate judiciary now thinks, why should I bother granting bail? Because someone above me will grant it. And then because it has been seen that the high court interferes. So we need to change the mindset of the judges in the subordinate judiciary as well as the high courts. And to some extent, maybe even the apex court in some matters. We must not shy away from doing the hard work. We can't simply wish that away. If we want to attract investment into India, the way we have to do a lot of work in having ease of doing business by giving infrastructure, ports, etc. We also need to make sure that there is effective judicial infrastructure and do all that hard work to make sure that when people come in and the biggest entrepreneurs from across the world come, they're not scared that someday some FIR will be filed against them for some innocuous place, and then they'll have to be run around getting bail. So we need to invest in judicial.
That's a fair point. Now, I'll go across to Justice Sikri for his closing comment for this series. And I also want to ask you, sir, that should we have to thank that we have vocal judges in the Supreme Court? They stick their neck out and make these statements. Many times we have seen that many judges absolutely refuse to speak. In that case, you actually don't even know what they're thinking. But thankfully, in the past 2 years, we've had vocal judges. They have spoken. You have always spoken your mind in all these years. With that in mind, if you could share your closing comment with all of us.
See, no doubt, judiciary, or at least at the apex level, Supreme Court has to keep on making efforts. And therefore, such an effort made by this bench and pass this judicial order, it is commendable. They will take it further. We are, at least I am hopeful of that as far as this bench is concerned. But I also agree with what Saurabh is saying. From my experience, let me tell you, in last more than 20 years, and about judicial academies, which he raised, the training sessions are there. It is continuously given. Judges are told about it, that you should not fear, you should grant bail, etc. But in spite of that, the things have not changed. And he has rightly mentioned there are so many reasons for that. Many times when the stakes are very heavy, the judges at subordinate level, they have so many fears. And some of these are already, flagged by Saurabh. And what he has said is totally justified. I may say from my experience that actually happens. And many times, even when the judge feels that bail should be given, he thinks that no, his own career may be at stake for so many reasons. And I need not go into that. I think message is loud and clear what I'm trying to convey. So therefore, because of those reasons also, many times the judges at subordinate judiciary, they are reluctant to grant bail, even when they think that the bail should be granted. They say, okay, let me not take risk. Let it be done by the High Court. And unfortunately, sometimes it has percolated even up to the High Court. Sometimes High Court judges also think in the same manner, let it be granted by the Supreme Court. And it is not only in the career, etc. And many times, as I said, some of these cases, they have the attention which is given in the media and the way they have media has stated about those. So they fear that if we still do it, there would be a backlash, and etc. So let us stay our hands. But then that is not the, judges don't have to fear with these consequences. It is the duty of the judge. That is why it is said, let the heavens fall, but justice should be done. So if a particular judge thinks that justice is to be done by granting a bail, that judge, he or she should not fear the consequences. But that is not easy. And therefore, it is not necessary that in spite of these judgments and what Justice Kaul and Justice Sundesh Menon are saying, and in spite of their taking the matter further and passing some further more directions as well, the things may change so easily. But there's another thing which I'll add, that today the very fear of ED or CBI arresting, and many times I'm saying this is the perception today, that many times these arrests are not warranted. And that fear is still there, that no, we may be arrested at any time. It is now up to these agencies as well, these investigating agencies as well, that they have to send out a message loud and clear to the society at large and business at large, that look, we will not harass people unnecessarily. And we will arrest only in those cases where it is absolutely essential. If they are able to have that kind of confidence, among the public or in the business houses, things may change. Otherwise, if the situation in the subordinate judiciary remains in the manner in which Saurabh has described, and this fear of ED, etc., exercising their power in an indiscriminate manner remains, this fear. I'm not saying that they are doing it, but at least that is the perception. And it is for them to remove that perception. So these are very, very essential things if we want to really improve the system of bails in this country.
Thank you so much for taking part in this two-part series on the law, on a new law on bail, nudged initially by Justice Kaul and Justice Sundaresh. It is said that in any society, the elders who had vast experience should contribute to its development. I mean, by this show, I can say that Justice Arjun Kumar Sikri, Senior Advocate Amit Desai, and Senior Advocate Saurabh Kirkal have contributed to the discourse on development of law, because unless vocal people speak out, how will this development happen? If nobody speaks, then nothing will happen, because nobody will get to know the views. That's why putting out views becomes so important. And a dialogue with the industry is also essential, because industry always says that without us, nothing would function. So don't treat us as crooks. We generate jobs. We take risk by taking a loan. And many times when we fault, it's not always that we are at fault. Maybe genuine business also goes bad. But leaving those thoughts there at it, thank you so much, Justice Arjun Kumar Sikri, Senior Advocate Amit Desai, and Senior Advocate Saurabh Kirkal for sparing time and joining us on such an important issue. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.